Hi, my name is John Griffith. I'm a divorce and family law attorney here in San Diego, California. This is one of a series of videos aimed at addressing common issues that come up in California divorce and family law cases. I should note that what I say shouldn't be construed or taken as legal advice. It's not intended to be legal advice. If you want legal advice, you should call a family attorney and talk specifically about your case. My office offers free consultations. If you'd like to discuss your case individually with me, give my office a call and ask for John. Today I'll be talking about what's called a paternity action in California law. And a paternity action is an action to establish paternity and custody rights for a child that was conceived outside of a marriage. So if you have a child of a marriage, then custody rights are determined as part of the divorce. If you're not married to the mother or the father of your child and you want to establish custody rights and custody orders and things of that nature, child support orders, then what you need to do is file what's called a paternity action. And either party can file a paternity action. Generally, if it's the father that wants to assert parentage and establish a custodial relationship with the child, he would file the paternity action in order to obtain some kind of visitation order or custody order. Now, if it's the mother and she wants to receive child support, then she needs to have the court establish a judgment of paternity. And unless the court determines that that person is the father of the child, they can't make orders for child support. So it's important that you file that paternity action, get a judgment of paternity. From the judgment of paternity, the court can then make orders for child support, binding the father of the child to pay child support. Now, if you've received a petition for paternity, it's very important that you respond to it. If you're the father of a child that receives a petition to establish paternity, and you have some reason to dispute the paternity of the child, and you do not respond to that petition for paternity, then the court could enter a default against you, finding that you are the father of the child. Now, if you're the father of the child and you agree, the mother files the paternity action, you agree that you're the father of the child, then all you have to do is go tell the court that you have no dispute with the paternity, and the court can enter a judgment of paternity, deeming you as the legal father of that child. Now, it's very important that if you have any doubt whatsoever, you request that you take a paternity test. Because if you go ahead and tell the court that you're okay having the court deem you as the father of the child, and at some point down the road you find out that you're not the father, if 2 years have passed from that judgment of paternity, then you're not going to be able to go back and contest paternity in most cases. And so while you may not be the biological father of that child, you are the legal father of that child, subject to child support orders until that child turns 18. So it's really important, if you're going to agree to paternity, that you're sure about it. If you have any doubt, just ask the court to order a paternity test and you can take care of it that way. Now, paternity actions are different than divorces. There's a lot of things that you need to look at, not only with respect to paternity, but also the underlying orders such as custody, visitation, and child support. My office is experienced in handling paternity actions. We offer free consultations. Call my office for your free consultation in any family law issue. I look forward to hearing from you soon.